But let me bring in my guests. Joining me this hour, celebrity divorce attorney Carlos Lastra and criminal defense attorney and former prosecutor David Bruno is with me as well. Gentlemen, thank you so much for joining me this evening. A lot going on today, but I want to start right there with the cross-examination of the first witness called by the state. I think the defendant is referring to the state or the prosecution as the plaintiff. Not completely clear. It kind of goes back, I think, to an earlier argument he was making, but I don't want to get too deep into weeds on that. But David, I want to start with you on your thoughts on that cross-examination. I kind of see where he's going with the intentional aspect, because I think that's a little bit of an issue in this case, but your thoughts?
My thoughts are it's like almost like a law school tutorial here on what an objection is and how to make an objection, and this is exactly why representing yourself is not advisable whatsoever. I'm a little bit confused about plaintiff. You know, was he referring to victims, the prosecuting attorney? Yeah, very, very confusing and disjointed, especially in light of the day's events that put him in another room outside the presence of a jury and the witness.
Carlos, let me get you to ring in before I take folks back into the courtroom.
Sure. I think that it's been a stark contrast. I think what I take away from this cross-examination is the stark contrast between the way he's acting in front of this jury and the way he acted earlier. It's almost Dr. Jekyll, Mr. Hyde. And what we discussed at our CNW litigation meetings is that the party to an action is the most important exhibit in the courtroom. How they act, how they respond to testimony, how they testify. Certainly are they respectful. How they dress, those are all important aspects. And what we've seen here, he doesn't have his shirt on. He's sending a message. Now, fortunately for him, okay, this hasn't happened to a great degree in front of the jury. However, I think that what he's trying to do in these instances is to bait the judge, bait the state to perhaps cause a mistrial, to certainly lay the grounds for an appeal. But what I find is very interesting is the way he's acting in front of the jury is the unintended consequence of that is that his competency, I think, is no longer going to be in question. He may be ignorant, but he's not insane.
Yeah, I would posit he's not.
Michael, just real quick.
Yeah, go ahead, David.
I wonder, though, because just before the witnesses, he was given an opportunity to come back into the room. And it was very basic questioning. Can you adhere to the court's rules? And he basically said he didn't answer directly. And he had the opportunity. If he's going to turn it on for the jury, he could have had an opportunity to go back into the room. So I just questioned that in light of those observations, which I agree.
Yeah, and I think and I agree with Carlos too, that what's become clear is that all that other stuff was probably an act. Because when he needs to keep it together, when it's required for him to keep it together, he can easily keep it together. And I disagree that he's ignorant. I think he's super smart. And I think he's planning this whole thing, the way he's going about it, and et cetera, et cetera. I think that's become clear. So I think that whole competency issue, you're exactly right, Carlos, is out the window. All right, guys, stand by. What I'm going to do right now, folks.